Item number 20, Lordship. Earlier occasion, my friend was used to take time. Today, I am having some problem, Lordship. I am not prepared, Lordship.
You are praying for time after time. If you're not interested, you should
No,
do it.
I am interested, Lordship.
He is a petitioner.
Yes, I'm petitioner, Lordship.
You're
Actually,
praying for appointment.
he was having outline bench. He used to go outline bench, so time could not.
You are before us praying for time, not he.
And today, Lordship, actually, today, actually, I have not gone through this college, and I'm not prepared today.
There are actually some complicated issues also. It was heard earlier by a different bench also. We could not come to conclusions, my
It
lord.
was hard.
So department is going to find a solution.
No, my lord. Definitely not. Definitely not. But
Give us
then
a date.
probably his preparation is not there today.
Actually, it will be any date, Lordship.
At joint request, item 20, at joint request, matter stands referred to be listed after 2.
I will mention, Lordship.
Yeah.
Oblige, sir.
May it please your lordship, my lord, in item 18, my lord, I have filed one IA today morning. My lord, if I pray, my lord, that can it be taken up on Monday?
Monday.
Yes. My lord, there is again, my lord, the registry has called for an interview on 5th of November. That is why. The notification was issued yesterday evening. And today morning, I have filed the IM in item 18.
You can call for the IA if you want today itself.
My lord.
You want it on Monday. You have some-
My lord, some difficulties in
All right.
this are,
Item 18 to be listed on
along with the IA, my lord, I am making the mention,
along with an IA, which the learned counsel for the
along with the IA number 329024.
file. Saying IA number
3290 2024.
3290-2020.
I'm okay.
I beg to mention item number 11 on behalf of the N. Shoikia Manor. He is out of station for the
Item 11 to be listed after 4 weeks.
My lord.
1 week.
1 week, my lord, first week of November.
Probably this
After
bench
2
will not be available.
After 2 weeks.
Clear.
May it please your lordship. Lordship, with regard to item number 19, your lordship, the matter was last listed on 22nd of October, your lordship. It was directed the matter will be listed before the appropriate bench, lordship. The matter is before your lordship today. Mr. RJ Das, the counsel for the petitioner, lordship, is out of station, the lordship. So I'm praying for an adjournment for a week, your lordship.
No, why should we keep it part heard? This is not an arbitration matter.
But lordship is very substantial regarding GST, you know.
I'm not taking up that bench, so I don't see why you should keep it part.
Lordship is very substantial, your lordship.
So we have heard substantially, we have
Lordship,
forgotten
lordship.
substantially also. All right, we'll give you one last chance. If you
Lordship,
want
lordship,
hearing, it's okay. List after 2 weeks, item 19. At the request of Mr.
N. Gautam, your lordship. I'm
N.
not-
Gautam, appearing on behalf of Mr. R.J. Das, counsel. Any consent required from the,
Lordship, I informed him.
you submitted that standing counsel PWD. So already been informed.
No, in item number 4, I've taken the consent of the other side. I am the petitioner. Pay for 2 weeks time to file an affidavit of service.
Let the matter come, item 4. Let it come.
I've already informed the other side. They may not. I'll ask it.
You put your junior colleague to renew the prayer if you are busy otherwise. If the item come with item 4 only, come just now.
I'll inform the other side accordingly.
May I please, your Lordship?
Right, please, your lordship. With the consent, lordship, I have filed an IA for withdrawal of a arbitration petition of number 31, lordship. Arbitration petition may be listed for next bench whenever is available. Withdrawal.
All right. Matter to be listed. You list it. No order is required. You list it. Give a date. You give a mention slip.
Lordship.
Give the necessary. Yes.
May I please, Lordship? With the consent of other side, Lordship, I beg to mention item number 60. Let it come after 2 weeks, Lordship.
No, my lord.
Some
I
personal
have
difficulty.
objection, my lord. It may be taken upon 4th or 5th of
That's
the
why I mean,
November, my
the
lord.
second week.
What is this appointment?
Appointment. It is covered case, my lord.
No.
Covered by which judgment?
by the Honorable Koteshwar Singh judgment.
There are separate, a coordinate bench
Series of
judgment is there.
cases were taken by the Honorable Court, and it was
Eh.
disposed of, an appointment was made
Against what?
against
Contract between
between the railway,
railway.
same party, same type of clause, similar clause is there here.
Clause 47 and 65.
63 and 64.
Even this bench has passed the note.
Yes.
Yes.
So what remains here?
Lordship, there coordinate bench decision was also there, otherwise no.
That is under challenge.
That.
And in
It
view of
was
the
not
bench
challenging this
decision.
way.
and in view of the latest judgment of the Honorable Supreme Court, SBI case, my lord, there is no scope for going into the hearing of the matter, my
You
lord.
tell us a date when.
On fifth,
On
Lordship,
5th November.
Not fifth, it has to be after 15. 19th.
19, my lord, I have some problem.
20 or 21,
21st.
Lordship.
My lord, sir, I have some problem. I have all
18. 18.
All right, at the request of learned counsel, matter be
on
adjourned.
on-
We listed
25th, my lord.
when the bench is available.
Lordship, 25th.
Not 25th, it has to be 26th or 28th.
Yes, 26th.
26th.
Lordship. Obliged.
You right, please call it. 26th.
May I please, Lordship? Well, this is an application for appointment of an arbitrator, Lordship.
Where is the agreement?
Agreement at a page, it starts from page 33, Lordship.
Where
And
is the clause?
clause at page 47, Lordship, clause 34.
Mr. D. Colita. Yeah, Mr. D. Colita.
Yes, Lord.
Learned counsel appearing for you. An application of section 5. Application and application. Right. The petitioner submit that counsel to the petitioner submit that an agreement was entered by and between the petitioner and the private respondent and the respondent. How many respondents?
Respondent, 3 respondents,
And
Lordship.
the respondents. Agreement was entered between
Between the petitioners and the respondent.
all the petitioners.
Yes, Lord.
Petitioner
Development
and the
agreement.
respondent. By agreement. By the deed number 144/2017. It was duly registered. By the senior sub registrar. It's so, as per the said agreement, the petitioners were the landowner, plot of land, entered into an agreement with the respondent for development of the land and building of residential units
Residential, Lord.
pursuant to the agreement being executed by and between certain disputes that arisen. It is submitted on behalf of the petitioner that the clause 34 of the said agreement, any dispute between the parties may be referred to arbitration. So, arbitration, comma, if the same cannot be settled. So, it is submitted that the dispute between the petitioner and the respondent not be resolved amicably according Where is your notice?
At page 39, 139.
Provisions of the application for appointment of an arbitrator. So this was issued on 6/5/2023 by the council representing
Their reply is at page 141
the same
and 140.
reply to on by the respondent by their reply dated 23/5/23.
That's 140, 142, 11,
140,
142. There are 11.
142.
Yes, sir. They have denied.
Whereby they stated that they are not willing to participate in the arbitration proceedings. So, being a great present petition 5/5/5, by petition, then should this hold steps on respondent by will court and propose within 1 week. Within 10 days. So, matter be listed after receipt of service report.
Apply.
Not appears to the clear occasion. MSP Saha, the town and great line. In the interest of understands after 2 weeks.
Make please, Lord. Malad, appointment of arbitrator. Malad, I have served a copy of all the respondents and they have appeared, my lord. Now, regarding the appointment of arbitrator, the clause is at page 45 of the partnership deed dated 26/8/2016. At page 45 is the clause, my lord.
You have filed some reply.
No, Lordship, I have no objection and arbitrator is appointed. Here, my lord.
What about 3 and 4?
Yes, my lord, they have received a notice by Justice Service. I have, there is an order, my lord.
But
They
you
received-
have not filed the affidavit.
Yes, I have filed the affidavit. It is,
You have.
an order was also passed.
Huh?
An order was also passed by this.
No, as per the last order, 6/9/24.
Uh,
6/9/24.
On 19th of August 2024, I have filed this.
No, do you have the
Record
last
of nine-
order? Do you have a copy of the last
Yes.
order?
6/9
6/9.
copy, I have not.
You have a look at this order.
Justice Service taken an affidavit also filed.
Yes, my lord, it is there in the record. The copy of the affidavit is there.
No copy of this is an affidavit filed prior. Then filed in August.
16/8.
But the last order passed is 6/9.
6/9, my lord, it was not in the record, that's why.
It is submitted by the learned after. I give a hard that pursuant to orders passed by this court on 16/8/2024. Service on respondent 3 and 4 was rejected, and dusty affidavit, affidavit confirming the dusty service has also been filed, and the same is available. Mr. Decca. Mr. A. Decca. Appears to respondent 1 and 2 submits that he has no objection to the prayer made in the stop. However, in spite of service being affected dusty and the affidavit affecting dusty service having been filed, none represent the respondent or 3 and 4. What about the other?
The last occasion they appeared. They appeared, my lord.
On earlier occasion, Mr. R. Das and counsel had appeared for 5 and 7. Where is he? Any objection by the other side?
No, my lord, no. Earlier they have, my lord, appeared and has not even prayed for filing any objection.
However, today when the matter is called up, Mr. Das is not available. None represent the respondent 5, 6, and 7 also. So no objection opposing the prayer made in the to be filed by any of the respondents. So under such circumstances, the court proceeds take up a petition filed under section 5 and pass the appropriate order. And the petition is filed by the petitioner praying for appointment of an arbiter. In terms of where is the clause?
Clause, my lord, at page 45. Clause 11 of the agreement, page 45.
In terms of clause 11 of the agreement,
Dated 26/08/2016.
entered by and between the petitioner and respondents. Who are the respondents? 5 and 6.
No, my lord, it's 1 and 2. Yes. Petitioner and the respondent number 1 and 2.
1 and 2. So who appears for 1 and 2?
I, Lordship, I am appearing.
You are appearing for. By the same agreement, the petitioner and the respondent 1 and 2 entered into a partnership under the name and style MS Gandhi Pro ARO Pro Energy Station. The agreement was executed by and between petitioner and respondent 1 and 2 on 26/08/2016. So, by the said agreement, the parties to the said agreement agreed to run a business under the name and style within quotes MS Gandhi Pro Energy Station. So the place of the business is at Babu Basti, Post Office Narangi, 78106, and the PS party in the district of Kanpur. So the nature of the business is to run a petrol pump. But in the said agreement, there is a specific clause, clause 11, which provides for arbitration. The same reads as under clause 11 to extend page 440. Then what happened after this?
Then, my lord, one civil suit was, my lord, filed by this petitioner, which is, my lord, at page 59. Because the petition respond number 1 and 2, my lord, appeared there and filed one mistake that they said, my lord, yes, because there is an arbitration clause in the arbitration in the agreement, my lord. Therefore, it should be referred to arbitrator.
Now,
Therefore, my lord,
now,
now that part is over, my lord. Now, thereafter, we, my lord, sent one letter to the respondent.
I find a deed of cancellation. What is that for?
Deed of cancellation is the first agreement, first partnership deed. That was in the year, my lord, 2005. Then, my lord, this is second one.
Okay.
Now, my lord, we have sent one letter at page 61 proposing two name of arbitrators. At page 61. They have not denied, and, my lord, they have not given any reply also. So, Lordship may prefer any one of them as they are.
To that, I have an objection, Lord. You may appoint from the list.
You said you had no objection.
Yes.
No, to the appointment of an arbitrator, I have no objection.
What happened, my lord?
No. If your period for objection is over,
Hmm.
and on top of that, you have not filed an objection. So if we agree with their prayer that they should be referred to arbitration, we'll have to refer to this arbitrator. During the course of executing the partnership deed and running the business, certain disputes arose between the parties. Partnership. This led to the petitioners approaching the civil court by filing civil suit.
Yes, my lord, it
Civil suit.
yes, title suit.
13/20.
Where does one find it?
It was filed in the year 2021. Yes. And one
suit.
miscase filed by them, my lord.
Title suit 13
13 of
13/20.
2020
of 2020
by this petitioner.
by the who filed the miscase?
Okay,
They,
file
whether
case
respond number 1 and 2.
1 and 2.
Miss case number 376 of
This case
2021.
is for referring it to arbitration.
Yes.
Yes. Three-
On a miscellaneous petition being filed by the respondent 1 and 2 being Miss Miss within bracket J, case number 376 of 2021 entitled to number 2. Prayer was made for referring the petition in view of clause 11 of the deed of partnership. So, the learned court of civil judge number 3000 approved by order dated 5/10/2023 referred the matter to arbitration. What order was passed in the suit?
Suit was dismissed, my lord. Since it was referred to the arbitration, my lord, therefore the suit was dismissed.
Is the order available here?
Copy, I think, in the yes.
In the insofar as the objection of the defendant on the respondent break or
It is a mistake.
civil judge.
No, that is a mistake. It is a mistake. It is-
The direction be issued to the plaintiff to produce uh, right the objection of defendant 1 and 2 within bracket respondent 1 and 2 hearing that the original copy of the partnership deed be called for effective disposal of the application filed by defendant 1 and 2. The same, however, dismissed on the ground that in view of the arbitration agreement, in view of the clause for arbitration, the same can be decided even in the absence of the original deed. Where it is submitted by the council to the part that subsequent in view of the presence of clause 11 of the agreement of the deed of partnership, whereby disputes were required to be referred to arbitration for markets gave to this list. By order, do you have at least the date of the order?
Yes, it was on the same day, my lord.
Same date, my lord.
5/10/2023.
5/10.
I order dated 5/10/2023. A copy of the said order has, however, not been placed. The learned counsel to the parties have been heard. Pleadings on record. The pleadings available on record have been carefully. It's seen that in terms of the partnership deed executed by the parties, ID deed number so it's dated 26th of August 2016. The petitioner and the respondents 1 and 2 entered into partnership deed, carry on a business of running an energy station for sale of fraud and other lubricants. By the said agreement, there is a clause in clause 11 which provides for referring disputes to arbitration. There is no the parties before the court do not dispute the the parties before the court agree that there are disputes between the petitioner one and petitioner and the respondent one, and because of which they had earlier approached competent civil court and in view of the presence of the arbitration clause, the proceedings came to be disposed of. Stop. Where is the notice?
Is 61, my lord.
The petitioner by notice dated 7/11/2023
2023.
issued a notice through his counsel, Mr. M. Sharma, through his advocate, Mr. M. Sharma, for appointment of the two arbitrators, either of the two arbitrators, for appointment of an arbitrator by choosing any of the two names mentioned in the notice. Any reply to this?
No, my lord. They have not filed any reply, no objection.
Pursuant to issuance of the notice, the petitioner, the respondent 1 and 2 did not file any response. So, before this court, counsel representing respondents 1 and 2 also does not dispute the receipt of the notice dated 7/11/2023. Stop. Where under clause 11, under clause 11.5, under clause 11 of the Arbitration and Conciliation Act 1996, the parties are free to agree on any procedure for appointment of arbitrator within bracket S. So, under section 11.5, upon failure of the parties to arrive at any agreement for appointment of an arbitrator within 30 days from the date of the request made by one party on the other, the appointment shall be made on an application made by party in accordance with provisions provided under section 11.4 of para. As discussed, there is no dispute that the notice dated so and so was issued by the petitioner calling upon the respondent 1 and 2 to agree on an arbitrator mentioned in the same notice for appointment proceed for arbitration. So, in so and so versus so and so, it is being held that where in terms of the provisions of section 7, one party goes upon the other party to appoint an arbitrator by way of proper notice, and where there is no dispute that the notice was duly received by the other party, and if they fail to appoint an arbitrator within prescribed period, 30 days, the date of receipt, the notice, the other party loses its claim for appointment of an arbitrator. So, in the present case, not only the respondent one and two does not dispute the receipt of the notice dated 7/11/2023, nor do they dispute that no response in terms of the said notice calling upon them to agree upon an arbitrator was not replied from us. In spite of opportunities being granted, the respondent has not filed any objection to the present proceeding. So, under such circumstances, in view of the law laid down by the Apex Court, the respondent one and two loses their right to raise any objection in respect of appointment of an arbitrator once the court assumes jurisdiction of the Section 11. So, when there is no dispute that an arbitration agreement exists between the parties, it is the duty of the court under Section 11 to proceed for appointment of an arbitrator. So, any or all objections pertaining to a dispute are entitled to be raised before the tribunal by either or both the parties once the parties appear before the tribunal appointed by the court. Accordingly, this court, under the powers under Section 11(6) of the Arbitration and Conciliation Act, appoint. Yes, who do you want?
One, serial number one.
Appoint Mr. Motilal Dr. Advocate, who is mentioned, whose name I mentioned in the notice dated 7/11/2023 to act as an arbitrator to resolve the disputes between the parties arising between them in terms of the partnership deal entered by and between them by way of agreement dated 26th of August 2016. So, the learned the appointment of the learned arbitrator, the appointment of the prospective arbitrator, however, is subject to the declaration to be furnished by the arbitrator under Section 12(5). Under Section 12 of the arbitration. Should we close it or
Yes, my lord. It should be closed, my lord. Because you're
subject to satisfaction of
The arbitrator.
Section 12?
section 12 with
Arbitrator যদি মানা করে
Better you appear before him, convey this order, get his declaration, then we'll close. In case he expresses difficulty, you'll have to look for order, another proceeding. So
Yes.
better finish it off. So the petitioner the prospective arbitrator. And request for a declaration. So the prospective arbitrator, if the prospective arbitrator, the appointment of prospective arbitrator will be confirmed upon receipt of declaration from the prospective arbitrator in terms of the arbitrator. Let the declaration under section 12 of the Code is on 26th November.
Obliged.
But seek some time to file an affidavit of service. Trustee service was effected on the arbitrator who happens to be respondent number 3.
All right, Mr. Ganguly, A. Ganguly, learned counsel for the petitioner, raised for and is granted 2 weeks further time to file the affidavit of executing trustee service in compliance with the order of the court. MS
Tinlong on behalf of Bitul Das, respondent number 1.
MS Suharto appears on behalf of
Respondent number 1, Bitul Das.
respondent number 1. Any objections to be filed?
Will be filed affidavit. Lordship,
Trustee service on whom?
Respondent number 3, the arbitrator. Therefore, 1.
Appears for respondent. And who is for 2?
2, Milords is earlier Milords 1 A.K. Roy has appeared for.
List of
Obliged, Lordship.
Lordship, I beg to appear in 5, 6, 7, and 8.
We'll take it up after the end of the list. We'll
Lordship,
take up these matters after the end of the list.
5 and 6, Your Lordship, they are taking, they request for time, I think, for filing reply.
We'll take it up after completion of this list.
Obliged.
Have received the instruction.
Yes, yes. What was the order passed here?
As per the instruction of the Land Spending Council, directed to file an application on from the portal, my lord, page 15. Page 15, Land Spending Council, NHM submits a representative that is not in the prescribed format and perhaps that is the reason as to why the representative of the petitioner has not yet been considered. Land Council for the purposes of at this stage, if that be so, then he be submitted to resubmit his application in the prescribed format, and such submission is not objected by the Land Spending Council.
So initially you filed it online or offline?
Offline, my lord, and I approached.
What is this, madam? You made a wrong submission.
Yes, sir. They have now all the transfers are pended, my lord, so they are taking.
No, the writ petition was closed on the basis of a submission made by
Yes,
you.
my lord.
That because
As
it
per the
was made
transfer
initially,
policy, that was their transfer policy, that was there, but now they are
so we'll impose a heavy cost on the state. You pay the petition. Yeah, this will entail recalling of this order. We have disposed of the writ petition and your submission,
Yes, my lord, as per the transfer policy.
whatever
that
it
was
may be.
Lord,
Your authorities must be concerned and aware about how,
this
what instructions they furnish to the
set
client.
or order, my lord.
Huh? Look at the order.
Well,
We have recorded your submission.
Yes. I'm sorry, my lord.
No, your being sorry doesn't help. You have made a submission on this and therefore it was disposed of.
Also followed the transfer policy, I have submitted that. And they have pended that for. It was recent order, my lord. They have pended
Art,
the.
Yeah, laptop.
Mr. J. Law School, Learned Counsel for the petitioner, MS Devoran, Learned Standing Counsel and NHM. Anyone else appearing? RM Das appears for NC Hill. Respondent 456. So, by this review petition, petitioner has sought for a review of the order dated 26/2/2024 passed by this court disposing of the writ petition with the following direction. In order to put for the petitioner was before this court seeking a direction that his application for consideration of transfer and posting as a physiotherapist in Karimganj Civil Hospital. In Haflong Civil Hospital. You want to go to Haflong
Haflong.
from Karimganj Civil Hospital, was not considered. So, the Learned Standing Counsel, upon being permitted to complete her instruction, submitted before the court that the application was not considered because the same was submitted offline. So, as per the transfer policy, all such applications were required to be submitted online. And accordingly, the writ petition was stopped. In view of the submission of the Learned Counsel for the Standing Counsel for the department, the writ petition was closed, permitting the petitioner to resubmit his application through the online portal of the NHM. So, whereas the petitioner filed this review petition on the ground that the portal of the NHM is not operating and consequently he could not file the said application as directed and permitted by the court, and therefore sought for a review of the order. The counsel for the respondent was duly permitted to obtain her instructions. So, today, when the matter is called on board, the standing counsel has placed before the court the following instruction. The instructions dated 3/10/2024. So, as per the said instructions, Learned Standing Counsel submits that transfer of all service delivery and program management staff, including physiotherapists, without replacement are pending before the authority except mutual transfer application. The portal for submission of transfer application has been closed. However, offline applications for transfer are still being accepted. The state headquarters NHM for record. In due course of time, transfer applications which are feasible for transfer without hampering public services may be allowed by the authority. Any order is issued regarding transfer is uploaded in the NHM website. So, then, a perusal of the instructions placed before the court reflects that the instructions which was reflects that the standing council reflects that the department is presently accepting transfer application in the offline mode, and the portal has been closed. So, under such circumstances, it is seen that the order dated 26/2/2024, which was passed by this court, disposing of WPC number 994 of 2024, was closed on the basis of submissions made by the standing council, which now submissions made by the standing council, that it is only through online mode that applications for transfers are accepted by the NHM. So this position appears to be not followed by the NHM department, and for which the petitioner can only faulted with. So the instructions also does not reflect as to the date from which the NHM decided to close the portal for accepting applications for transfer in the online mode. So, in the absence of any specific dates referred to the instructions placed before the court, or in the absence of any such date, on the basis of which submissions are made to the court, that submissions are made to the court to reflect the date from which the NHM had stopped accepting online applications for transfer. It will have to be presumed that on a date when the WPC number was disposed of by order dated 26/02/24, the NHM, the policy in the NHM, NHM's policy of accepting online application was still in force. So, this order was passed in the presence of the standing council, and therefore non-compliance of this order may lead to a contumacious action against the respondent from this court. So, the instructions also do not reveal as to when this order was brought to the notice of the mission director NHM, and when the decision to change the policy to accept application, transfer application in physical form and not in online form was taken, and obligor when the NHM portal and as to when the provision in the NHM portal was for submission of on transfer application in the online mode was done away with. So such conduct, according to the court, is prima facie contumacious. So there is no explanation as to why the direction of this court was not complied with. And be that as it may, considering that the instructions now reveal that prima facie reveal that the NHM has resorted for acceptance of online acceptance of offline application for transfer, this court considers that it will be sufficient to modify the order dated 26/02/2024, passed in WPC 994 of 2024, to the extent that in addition to the directions contained in the order dated 26/02/2024, the petitioner will now be permitted to submit his application in the offline mode before the NHM authority. So, they say application file that may be filed by the petitioner within 2 weeks from today will be duly considered and necessary orders on the said application be passed by the NHM authority and served on the writ petition. So, to that extent, the order dated so and so passed in WPC so and so stand modified. So, the order passed today shall be read together with the order dated so and so passed in WPC so and so. So, the review petition is accordingly disposed of in terms of the above orders. So, this court expresses its displeasure, strong displeasure, in the manner and the conduct of the mission director NHM in refusing to carry out the directions contained in the order dated without indicating that on the date and when the order dated on the date when this order was passed in WPC so and so disposing of the writ petition, there was already a change in policy. So, however, we hope and express that the directions contained in the order will be carried out by the respondent mission director in right orders. Review petition.
Entire exercise may be completed within a completed period. Representation. I'll file within 2 weeks, but
He'll file it in 2 weeks, a representation. And they say representation is filed within 2 weeks shall be considered and disposed of in further period of
date
Yep.
level.
time. Copy of the instructions received is
May I please, Your Honor?
May I please? They have filed objection, my lord.
You have
Yeah.
filed.
filed
That-
it, Lordship, but
It was,
I have checked that it has not come up in record, Lordship.
Mr. Resto here for the petitioner, MSD Decca. Learned counsel appears to respondent 1 and 2. MS Decca submits that the respondent filed their objection. The same, however, is not available in the case report. Matter be listed after 2 weeks by the registry by placing the objection stated to be filed by respondent 1 and 2 on record. This report.
My lord, in this case, the counter affidavit has to be filed by the respondent.
Railway. Is it railway?
Yes, my lord.
Yes,
Same contract,
Yes,
yes, my lord.
same clause.
same clause.
20% issue, my lord.
Here it is also covered by the judgment of the Honorable Justice Koteswar Singh. I have annexed also.
Yes.
We'll file a my lord, short affidavit, my lord, because I have received instructions on 23rd only, my lord. By next
Right. Mr. R. Hussain appears for the petitioner. Mr. H. Gupta appears. Daniel CTC appears for the respondent. Mr. R. K. Dev Chaudhary along with Mr. H. Gupta appears
No.
for the respondent because your name was recorded earlier. Mr. Right, Mr. R. K. Dev Chaudhary appears for respondent number 1 and Mr. H. Gupta appears for respondent 2 and 3. The respondents submit that they be permitted to complete their instructions. This again after 2 weeks. From date to be given by the registrar.
Right. Yes, sir.
Yes.
Section 11, appointment of arbitrator, department is railway, my lord,
Who's for the department?
and they have filed an affidavit, my lord.
Affidavit has been filed, Lordship.
What does it say?
The railway has sent a panel of 4 retired railway officers as an arbitrator, Lordship. They have not answered to it.
That is barred under 12(5).
12.5, Lordship,
Yeah,
it is,
wait. No, then-
That communication, pursuant to that communication, we have come before your law.
That is covered.
Lordship, since under 12.5, there is conflicting judgment, Lordship, and larger bench, Lordship, judgment has already reserved.
Maybe is covered by that Orpeta.
Borpeta and Borpeta was appealed before Supreme Court, the SLP is dismissed.
You give us that order.
But
Both the orders.
Both the
we are relying, Lordship, the central organization for railway electrification.
That is referred to larger bench.
Yes, Lordship, already hearing is complete, Lordship, as per my instruction, Lordship, on
Then
38.8, and judgment is reserved.
let us do like this. You both you prepare a short synopsis,
Lordship.
bullet point, and place it before the court on the next disposition.
Okay.
In the meantime, the judgment comes, doesn't go by whatever is laid down in Ladakh.
And another judgment, in-depth Sudhani has also dealt with the point. A different line of thought, but that also I'll place before.
You give it first.
Yes, sir. He has also dealt with, actually, one of what is that, Delhi High Court made an observation that while deciding this aspect that whether the contractual nominated arbitrators, despite being departmental, will prevail or not, Delhi High Court said that it has not discussed about 12.5. That independence and impartiality aspect was not gone into.
Who has not discussed?
My lord, the Delhi High Court said that Supreme Court has not gone into in that whole that judgment. So another view was taken where these judgments have been bypassed and appointments have been. Justice Arundev Chaudhary has recently taken as view. I have placed it before. Sorry, sir.
I think the central organization commission help that the rider of agreement or waiver gives the protection the,
Railway.
the mandate of 12.5. But it does not, even in this judgment, central railway,
The core judgment.
it does not deal with a situation. What happens if they refuse?
That is.
Since when the agreement specifically provides for appointment of arbitral tribunal consisting of 3 arbitrators from out of the panel serving or retired railway officers, the appointment of the arbiter should be in terms of the agreement as agreed by the parties. That being the conditions in the agreement.
Then you have to answer the requirement of 12.5, notwithstanding any agreement. How do you overcome that?
Lordship, they have consented, this agreement was executed after, in 2018, after the coming into force of this.
Kindly go to the process of the
Yeah, yeah, yes, Lordship.
Very clear. That's
Lordship.
how you overcome that.
This is a question, Lordship, already judgment is pending.
Have you gone through the judgment by appointed bench?
Barbata is there, Lordship, with me.
Share a copy.
Yes, Lordship, certainly. Okay. It will go for that.
Mm.
We can take it up next week.
Lordship.
Just give us the factual. I heard council, Mr. R. Gautam, council. And Mr. R. Devi appears to be as agreed to by the council. That the matter, since the you have filed your reply,
Lordship.
since the pleadings are completed, that the matter be listed for exposal at the admission stage or '29th. Okay. Let us keep it after 2 weeks. Let us have it on say on 19th November.
19th of 19th of
Obliged.
19th November.
deeply obliged.
My lord, in item 5, I'm appearing today, my lord, we need to take some instructions.
Yes, heard. Mr. Fukan, the respondents appear.
Yes, Your Lordship. So in 5 and 6, Your Lordship, they'll have to file reply. But in item 7, actually, we have instructions to withdraw this application,
right.
item 7. And in item 8, Your Lordship,
So we'll go one by one.
Yes, yes, yes.
Item 5, Mr. Sahiwala.
AK Sahib. AK Sahib.
A.K. Sahiwala appears for the respondent.
My lord.
He submits. He prays for 2 weeks' time. Complete his instructions and file objections if so. Mr. A. Pupat, and what is your name?
SRN Nasir.
SRN Nasir appears for the let the matter be listed after 2 weeks.
Actually, may I request for a specific date? Because actually, these are contractual employees who have not got their salaries, even for the period for which they worked.
22nd November.
Obliged, obliged.
22nd November, man.
Yeah.
Similarly, my lord, number 6.
Same order in item 6, Your Lordship.
Let us have it on 21st November. Sorry. 21st November.
No difficulty, Your Lordship.
Yeah. Similar orders in item number 6. Mr. A.K. Sahiwala, IPS. Also fixed on 21st November.
Item 7, we have instructions to withdraw the petition, Your Lordship.
Mr. Pukan, A. Pukan, General Counsel to the petitioner, submits on instructions that the petitioner does not wish to press the petition any further. Accordingly, the arbitration petition stands dismissed as not pressed. Notices issued are recorded.
My lord,
Item,
in this number 7, my name may be reflected.
Can you write Mr. A.K. Sahiwala appears for respondent? However, petitioner submitted on instruction to recall. Accordingly, same stands dismissed as not pressed.
item 8, Your Lordship, unfortunately, the petitioner passed away. So we
Oh.
would like to take steps, Your Lordship, for substitution.
All right, it is submitted that the petitioner, during the pendency of the petition, passed away. So, learned counsel for the petitioner, grave the leave of the court, take necessary steps.
This may also be
Steps
kept
for
on.
substitution.
Yes.
Para Mr. A.K. Sahiwala appears for the respondent. List after 4 weeks.
Lordship, it may be kept on the same date because
Same day.
ultimately it can be all decided together.
All
is
right.
my- Yes.
No, but you'll have to file some application.
I will do that. I will do that.
All right. Please start 21st.
Lordship, may I pray one more prayer, Lordship? You have mentioned for withdrawal of another arbitration petition number 31. So that may be listed on 21st, Lordship.
You may give a mention memo.
I had already given, Lordship.
It's all connected. It can be taken up together.
Deeply obliged.
Deeply obliged.
Obliged, deeply obliged, Your Lordship.
Yes.
Not the,
Your objections are filed.
My lord, not filed, my lord. No, no, recently only I have received. About 1 week's time I will file, my lord.
Mr. S. Deka appears for the petitioner.
Actually, counsel from outside is in PC, lord. PC to accept.
He is not joined as yet. Mr. H. Gupta appears for the respondent.
My lord.
Submits that his instructions to appear in the matter. He submits that he would like to complete instructions.
He received the instruction.
He will file affidavit, my lord, within 2 weeks, my lord. Outer limit of
He
2 weeks.
can file necessary objections if so required. Accordingly, matter be listed after 2 weeks.
Date may be fixed, lord.
Twenty-first.
21st of November.
Obliged.